Some opponents of Obamacare argue that that single phrase in the law should be interpreted literally. Only the state exchanges can offer insurance subsidies. And up to this point, their argument has only managed to convince a few conservative judges. But now it will go before the Supreme Court. And if a majority of the justices buy the argument, according to one estimate, listen to this, 4.7 million people would lose their subsidies and probably their insurance, and the individual market as a whole could very well fall entirely apart. Joining me now, Tom Goldstein, co-founder and publisher of SCOTUSblog.com, blog covering the Supreme Court. He's argued numerous cases before the court, including as a member of former Vice President Al Gore's legal team in Bush v. Gore. Tom, you surprised he took the case?
I'm not. It seemed destined for this to be a Supreme Court case. The issue is so important. The legal question, even though the administration's likely to win, is really close. The justices are familiar with the law. They decided, I think, that they need to take it now because a lot of the provisions that are affected by the subsidies go into effect over the next couple of years, and so they decided we've got to get an answer.
Why do you think, you just said the administration is likely to win. Why do you say that?
Well, everybody knows this statute is a bit of a wet mess. There are a bunch of provisions in it that aren't clear, and there are hundreds of them that the administration has had to implement. Executive agencies all the time have to interpret ambiguous provisions in the laws. And this is just one of those where there are other provisions of the same law where there's a reference to an exchange that's established by the state that everybody agrees actually has to be referring to the federal government. And I think that's what happened here, and the administration reasonably said, look, because the law says the states will establish the exchange, that's why there's the reference to these state-established exchanges. But the law also says, hey, if the states won't step up and do it, the federal government has to take care of it.
Here's one of the things I think about. The Supreme Court is a legal body, but it's also a political body. It exists in the world of politics. And I think about the day that the Supreme Court announces to 5 million people, you're now going to pay $2,000 more or $3,000 more, insurance that you utterly cannot afford. We're basically going to destroy your insurance. And I just imagine what that would do to the institution of the court for the court to announce such a thing.
Well, I have to say that I think if the justices really believed that the law required that result, they would do it. They would say with regret, and they'd say go back to Congress and get a new law. But if it's a close case, the law says, the doctrine of the Supreme Court says, you give the administration the benefit of the doubt. And what I really learned in the last challenge to Obamacare that you talked about in introducing this story is that the 5-justice majority there, including the Chief Justice, decided, look, this is a political question. It's not one that's going to be resolved by the Supreme Court. We've been debating health care for decades, and we're not going to overturn it. I think the same thing's probably going to happen here.
There's also a key precedent here. You made this point. I just want to sort of reaffirm this. That statutes are complicated all over the place. It's not just the Affordable Care Act. I mean, statutory interpretation is a complicated undertaking, and agencies that implement laws have to do it all the time, and they get contested a lot. And there's some pretty good Supreme Court precedent that says basically you defer to the agencies, right?
Yeah, the world has to work that way because there's so many laws that it's unclear exactly what Congress wanted. The job of the executive branch is to put the laws into effect. And so the Federal Register, which is the document that produces these regulations, is filled with, there's got to be hundreds of thousands of pages of regulations. And the rule of law is if the statute's ambiguous and the agency is charged with implementing the statute the way that the IRS is here, then it gets to interpret it.
Tom Goldstein, thank you very much.
Thanks for having me.